Those of you who have decided to remain for the rest of the afternoon, you've done yourself a favor. Professor Carrington, who will wind up the program, is, in my judgment, among the most distinguished authorities on the Constitution, the role of federal judges, and to be more specific, civil procedural rules than any authority in the country. So I asked Judge Brennan what it is he wanted me to talk about. And he said, well, talk about whatever you want to talk about, just two conditions, keep it loud and short. So I'm committed to do that so that Professor Carrington can come and visit with us a little earlier than he might otherwise have. Because Tom Brennan did not assign a specific topic to me within the concept of this Article 5 discussion, I have selected one I think you'll find kind of exciting. I hope you do. My topic is the need for a constitutional amendment to guarantee that there will be no adverse estate tax consequences for invading the corpus of an inter vivos pour-over trust with cross-contingent remainders. A lot of people talking about that. I accept as a given that an Article 5, a mandatory convention, is both feasible and desirable. My time and my assignment today I take not to anticipate that I will offer any specific proposals for the manner in which any part of our Constitution will be amended, but I take it that I can perform a bit more useful function if I share with you my opinions, my personal opinions, about a couple of areas in which an Article 5 amendatory convention could do some great work in whatever way the delegates were to decide that work should be done. The first one is my concern about a carefully thought-through belief that the United States Supreme Court is completely out of control, and that as a consequence, the federal judiciary in substantial part is out of control. Out of control with respect to the controls imposed by the United States Constitution. Thus far, I haven't seen any ukase handed down by the United States Supreme Court which is directly and immediately damaging to the welfare of the people, aside from their economic, cultural, and social welfare. But the Supreme Court has meddled so inartfully and so unconstitutionally and so dangerously in our American culture that it's time for us, in my view, to say, thus far and no farther. That would mean a look, in my opinion, at Article 2, Section 2 of the United States Constitution, in which the President is empowered to make appointments to the United States Supreme Court, and to look at Article 3, which presently describes in, as you know, a very brief and almost summary language, the authority of the court. So I'd like to make a few observations about that. I'd also like to make a few observations about the advice and consent responsibility of the United States Senate, which is given us by the Constitution, and I think that needs discussion. That is to say, the notion of a workable, wise amendment to the advice and consent power for the appointment of federal judges at least, and particularly for the appointment of United States Supreme Court justices, needs another look. To give you kind of a feeling, if I may, for how this interest of mine and these conclusions I've reached were reached, I beg your leave to let me make personal reference, a personal experience. About 10 years ago, about 9.5 years ago, I got a call from the Chief Judge of the Sixth Circuit, Gil Merritt, who said, as you know, Jim, there is a necessity of a decennial census under our Constitution, and there's a necessity. The United States Supreme Court has said that the congressional seats in each state be reapportioned. That is to say, the vote of the people through their congressmen in each state must be reapportioned decennially. And I said, yeah, I remember that from the final exam. That's about as much as I know about that. And he said, the liberals have filed a lawsuit in Wayne County, and the conservatives have filed a lawsuit in Grand Rapids, each of them proposing a plan for redrawing the congressional districts in the state of Michigan. Obviously, the liberals' proposed plan advantages Democrats, and the conservatives' proposed plan submitted to Judge Bell in Grand Rapids favored the conservatives or the Republicans. And so I want you to serve as the presiding judge in a 3-judge panel, which the law calls for, to decide on what the districts will look like for the next 10 years in the state of Michigan, the congressional districts. And he said, I think when you read the pleadings in the papers filed by the Dems and filed by the Republicans, you'll see that the shift in population requires a reduction of 2 congressional seats in the state of Michigan. This phone call comes in the middle of the afternoon when I'm reading briefs or doing whatever I was supposed to be doing about some of the rather mundane work, frankly, of the United States Court of Appeals. So I laid some of that aside and started studying. Cutting to the chase, it turned out that the 3-judge panel, consisting of Judge Bell from Grand Rapids, Judge Newblatt from Flint, and I began to conduct a trial. It was over here in the federal courthouse, 2 or 3 blocks away. And what it amounted to was the Democrats, through Mr. Brewer, attempting to persuade us, the 3 of us, that the Democrat plan for configuring the districts for the state of Michigan beginning in the year 2000 was most in compliance with the mandate of the United States Supreme Court for how many people will be in each district. The Constitution has nothing to say about that subject. And the Republican lawyers were making the same argument. Neither of those proposed plans struck me as fairest in terms of meeting the Supreme Court's mandate that there ought to be the same number of people in each congressional district. That's very hard to do because during the time of the trial each day, people were dying someplace in Michigan. So the number of persons in that congressional district was changing. And no evidence was offered about the number of births in any particular area of the state of Michigan each day. So there was a lot of winking and nodding going on. When it was all finished, the other 2 judges said, look, 3 of us can't draw a map. Only one of us can do it. Ryan, you do it. And none of us like the Democrats' map. None of us like the Republicans' map. So I said, yes, sir, I'll do what I can and submit it to you 2 as soon as we get a map drawn. So I spent every evening for almost 2 weeks, weekends excluded, over in the Cass building in the basement with a young man who is a techie. Is that what you call them, techies? He was, to my way of thinking, a genius on computers. Now, I know a lot about computers, I assure you. I mean, I know you got to turn the switch on in the room where the computer is to get the light on. I know that part. But this guy was magic. And following the findings of fact that our 3-judge panel was making each day and would announce at the end of the trial, this guy attempted to draw a map with his computer that most nearly complied with the United States Supreme Court's mandate of districts of equal number of people. And, well, to finish this example, it occurred to me not more than halfway through that process that this is outrageous, that one federal judge should have the authority to configure the congressional districts of the state of Michigan, make findings of fact and conclusions of law, and hand that to the people of Michigan and tell them what congressional district they live in, and to decide who of the 16 congressmen would lose their districts entirely. The point here is obvious. You do what the law requires you to do when you don't sit on the United States Supreme Court, and I didn't. And the map was drawn, and if you have any interest in this subject, you can look at the opinion, which is buried somewhere in Fed Second from the year 2000, and you'll see that just for the fun of it, we renumbered the districts. The numbering of the congressional districts through the 1990s didn't make any sense. The numbers are all over the place. The 15th district was in Detroit, and the 1st was upstate somewhere. So just for the heck of it, I renumbered all the districts so that they would be sequential in terms of geography. And that seemed like an orderly thing to do. And submitted the proposed map to my two colleagues. It took a number of days to study it, see whether it conformed to the evidence we had taken. A lot of testimony. Congressman Dingell testified, Congressman Levin testified, and some really impressive submissions on constitutional law and districting by the lawyers for both sides. And my brothers thought that plan was okay, and then we made our findings of fact, conclusions of law, and attached the new map on the day we decided the case.